Well, welcome to the final round of the 31st Annual National NNALSA Moot Court. I know many of you are competitors, and thank you for being here once again. Thank you for staying, although you may not be arguing in the round. To the competitors that will be presenting this evening, best of luck to you. I just wanted to start by saying this has been a labor of love for 8 months, and I can see the community that we're already building based off of it. So thank you very much for this opportunity. I've got a few points to go through before we start the round. And then I'm going to hand it off to Professor Helton. And following his statements, our bailiffs will begin the all rise and the justices will come in order. Before the final round begins, Professor Robertson, one of the judges, would like to make some few statements regarding some members of the Indian law community that we've lost recently in the past couple of years. And so before we gavel in the round, he would just like to address that. I also would like to give a land acknowledgement. So long before the University of Oklahoma was established, the land on which this university resides was traditionally the home of the Caddo Nation and the Wichita and affiliated tribes. We acknowledge this territory once also served as a hunting grounds, trade exchange point, and migration route for the Apache, Comanche, Kiowa, and Osage nations. Today, 39 tribal nations dwell in the state of Oklahoma as a result of settler and colonial policies that were designed to assimilate Native people. The University of Oklahoma recognizes this historical connection our university has with the indigenous community. We acknowledge, honor, and respect the diverse indigenous peoples connected to this land. We fully recognize, support, and advocate for the sovereign rights of all of Oklahoma's 39 tribal nations, and this acknowledgement is aligned with our university's core value of creating a diverse and inclusive community, and it is an institutional responsibility to recognize and acknowledge the people, culture, and history that make up the entire OU community. Outside of that, thank you all for being here once again. Time providing, judges will provide oral feedback following the round before they enter the room for deliberations. I will determine at that time whether we have time to do that, but as of now, I believe we will. So this may be the last time you hear me speak. No, I'm kidding. I'm going to speak at the banquet. I'm going to pass it off to Professor Helton to give a little factual and background summary. He's one of our problem authors, along with Professor Pearl. And so can we please get a round of applause for our problem author?
Thank you, Palmer. Thank you all so much. It's I've always coached our moot court teams, and this is my first chance to see what those teams might do with a problem to which I've contributed. And Professor Pearl, it was a delight writing this with you. 2 centuries ago, in the last week of February, John Marshall created a new form of title, a new form of property, in order to underpin principles for westward expansion. He imagined an orderly but inevitable westward expansion, and he fantasized, I think, about a disappearing Native person. And in our time of tumultuous weather and tumultuous climate and uncertainty, I see hope and promise as I look out, because I realize that was a story of survival to which he contributed a chapter, not just a story of settlement or colonialism. So when I look for hope in the world, I see a whole bunch of hope in those of you who have come here to sharpen your skills so that you'll be better advocates and better advisors for your clients and for tribal communities around the world. As I mentioned, we are living in a time of climate catastrophe, perhaps a 6th extinction round coming, and dramatic change in terms of the climate, freshwater scarcity, special survival, and human survival. And around the world, I think there's been a recognition that the current participants have not successfully addressed these problems. And so there has been a search for new participants. people looking to children to bring lawsuits to represent the future in the context of climate change. And indeed, people finally acknowledging what we've done for a long time, which is to recognize that a river has a cognizable personhood. We are seeing rivers in North America and in South America being recognized as persons, plants like wild rice, stands of trees, and a variety of other natural resources being added as participants in our legal system, I think because of this acknowledgement that the current participants in the system aren't doing a good enough job. And so in this case, you've all come together to talk about a fictional plant used by a fictional people in a fictional place. But the stakes are very real in this conversation, and the skills you've all developed competing will help you contribute to solving those problems in the future. And they say that middle age is when you stop blaming the generation ahead of you for all of your problems and you start complaining about the generation behind you. I like to think I've been an equal opportunity complainer all of these years, and yet when I look for hope, I find myself looking to faces less wrinkled than my own for that hope. And so I really look forward to seeing what you all wind up doing. So this fictional people is the Minneshanka Nation. The fictional plant looks very much like the Cherokee River cane. It is a species of bamboo in North America that has, it turns out, lots of good uses, including historical and cultural uses, but also things like phytoremediation. And so the tribe wants to protect that plant, has taken a variety of steps to do so, including passing a resolution granting juridical personhood to the Minneshanka River cane, or the Minneshanka cane, with whom these people have lived for so long. Mr. Randall, one of the parties in this case, he is a descendant of an original Alati of the Minneshanka people. In this case, he has 3/16 degree of Minneshanka blood, but when he was born, he was not eligible for citizenship due to the higher blood quantum. He later becomes eligible for citizenship, but does not sign up for citizenship, continuing to live on what is now a fee land within the original boundaries of the reservation. And he wants to have a development project take place on that land that will promote economic development. The tribe wants to preserve this space for the Minneshanka cane that is already found on that property. So we have not a clear evil wrongdoer in the case, but instead two participants that appear to be motivated by sort of ordinary values and conduct. So our participants have two questions. Is Mr. Randall's Indian status sufficient to render him subject to Minneshanka Nation power of eminent domain? And secondly, does the Minneshanka Nation have the inherent authority to protect Minneshanka cane on non-member fee lands within the Minneshanka Reservation? And that is what you've all worked so hard on for so long, and that is what we are about to discuss as our judges enter, or as our justices enter. I am grateful to you participants who have worked so hard for so long, to the coaches and families who supported, and to the judges who judged all of the rounds up to this point, and the justices who join us now. Thank you all.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court. Oyez, oyez, oyez.
Thank you. You may be seated. This is the Supreme Court. Before we proceed, we do have a few words that our Associate Justice would like to proceed.
Yes. Thank you, Mr. Chief Justice. Just before we begin, and this is sort of not on the agenda, but we lost three major figures in federal Indian law. in the last couple months, and I wanted to acknowledge them. And after I say a brief word about each of them, ask if you would join me in a moment of silence in their honor. Alex Skabeen, who was a good friend of many of us and a professor at Utah Law School, passed away within the last few weeks. Dennis Arrow, also a good friend of many of us at Oklahoma City University Law School. And then a man that most of you probably didn't know, and many of you probably never even heard of, James Abourezk, passed away on Friday. Since he's probably less well known, I thought it important to say just a brief word about him. He was a senator from South Dakota, non-native, Arab American senator from South Dakota, raised in Lakota Indian country, went to the U.S. Senate in the 1970s, and when there, sort of made Indian law and tribal sovereignty his mission. He revived the Senate Indian Affairs Committee, which is still an important body, and was principal author of the Indian Child Welfare Act and the Indian Self-Determination Education Assistance Act, two of the signature early self-determination era federal statutes, one of which, of course, is coming before the Supreme Court for an assessment of its constitutionality. I got to know him, this little more autobiography than I intended, but he was partner after he left the Senate with two guys who became my partners because he packed up and left, decided DC was no longer a livable place, and moved back to South Dakota. And these guys were left with clients, needed to hire a young lawyer who would do anything he was asked to do, and that turned out to be me. And so Jim Abourezk is how I became his abandonment, I guess, of the District of Columbia. It's how I became an Indian lawyer. And so he's always been a presence in my mind. And I wanted to sort of share briefly his story. He was much older. The first two were in their 70s. Senator Abourezk was 92, ripe old age of 92. But in any event, I appreciate your allowing me to share a word about their passing, and if would be especially grateful if you would join me now for a moment of silence in their honor.
Senator Gassada, thank you. Today we will hear the case number 22-1491, Minneshanka Nation petitioner versus Aaron Randall, respondent on petition for writ of certiorari from the United States Court of Appeals for the 13th Circuit. Is petitioner present? Petitioner 1, you may proceed to the podium. Do you wish to reserve some portion of your time for rebuttal?
Yes, petitioner respectfully requests 2 minutes for rebuttal.
All right, 2 minutes. You may proceed.
Chief Justice, and may it please the court, my name is Emily Depew, and I, along with my co-counsel, Chris Berzer, represent the petitioner, the Minneshanka Nation. An individual who lives within the boundaries of the Minneshanka Nation reservation takes advantage of the nation's services and has a deep ancestral connection to the tribe must be subject to the nation's inherent power of eminent domain. The nation can condemn an easement over Aaron Randall's land because first, the nation can exercise its inherent power of eminent domain, and secondly, Mr. Randall's Indian status is sufficient to render him subject to the nation's power of eminent domain. Therefore, petitioner respectfully asks this court to reverse the decision of the 13th Circuit Court of Appeals. First, the Minneshanka Nation has the inherent power to exercise eminent domain over Mr. Randall's land. Tribes retain power to exercise their inherent sovereignty unless explicitly divested by Congress or unless that this court finds the exercise of such power is inconsistent with the tribe's status as a quasi-sovereign. Here, neither exception applies. In Boone Company versus Patterson, this court stated that the right to exercise eminent domain is inherent in all sovereigns.
Have we ever found eminent domain on behalf of a tribe before?
Your Honor, petitioner is unfamiliar with any case where this court has specifically addressed the constitutionality of a tribe exercising eminent domain. But this court has
How
said
about any of the circuit courts?
in the circuit courts, once again, many circuit courts have not addressed this issue of tribal eminent domain, but there have
Not
been.
many have any.
Your Honor, petitioner once again is unfamiliar with any case that would be directly on point to the facts of this issue at hand. But in the Western District of New York, in Seneca Constitutional Rights Organization versus George, the district court did find a lawful exercise of tribal eminent domain, specifically relying on this court's precedent in Boone Company versus Patterson, where this court stated that the power to exercise eminent domain is inherent in all sovereigns.
Counsel, this is the 200th year anniversary of Johnson v. McIntosh. How might you square that case, notwithstanding how old it is, with this particular power you claim?
Petitioner rejects the reasoning in Johnson versus McIntosh, relied on a problematic racist doctrine of discovery, and petitioner sees that Johnson versus McIntosh, it doesn't necessarily need to be applicable in this case. Sure, in Johnson, this court did hold that tribes don't have the ability to freely exercise alienability of land without the United States being an indispensable party in that suit. But here, the power of eminent domain is a power distinct from alienability. The power of eminent domain is inherent in all sovereigns. Even Congress has recognized this retained right of tribes. In the Indian Civil Rights Act, Section 1302(5)(8), Congress stated that tribes must provide just compensation when exercising the power of eminent domain.
Do you
No.
consider eminent domain to be a power that effectuates a transfer of property or a transfer of title?
Certainly, in some cases, that might be the instance, Your Honor. But eminent domain is an integral attribute of all sovereignty that does have that transition of title, as you stated, from either an individual to a particular sovereign. But once again, petitioner rejects the reasoning found in Johnson versus McIntosh and does not necessarily believe
But
that
the
it's.
Minnesota Nation, are, as are all Indian nations, tribes, are not full sovereigns, are they?
This is true, Your Honor. In
And
Montana,
so the question then is, what aspects have they given up when they were subsumed within the United States as quasi-sovereigns or semi-sovereigns, whatever that might happen to be? Because obviously we're not, even the Worcester versus Georges, where they said the state has no play within the reservation or the boundaries at that time, has obviously been jettisoned by this court.
petitioner believes that the fact that this Minnesota Nation is, quote, a quasi-sovereign does not factor and should not factor into this court's decision. Because, as I stated, tribes retain all inherent sovereign powers unless explicitly divested by Congress or unless this court finds it inconsistent with the tribe's status as a quasi-sovereign. Neither Congress has explicitly divested this tribe of the power of eminent domain, and this court has never addressed this issue to find that it is inconsistent with the tribe's status.
Question returning Johnson versus McIntosh. You said several times you reject the reasoning. I'm not sure that's among our options. I mean, it's our decision, and you're not suggesting that it's bad law that we shouldn't apply, I guess. Or is it your position that if we don't overrule Johnson versus McIntosh in this case, then you lose?
This court can obviously have the power to overrule Johnson here and today, but it is petitioner's position that you don't even necessarily need to deal with the exact holding of Johnson to reach a conclusion in the side of favorability of petitioner. This court can rely on its longstanding precedent that tribes have the inherent power to exercise the rights that predate the formation of the federal government. Beyond Congress explicitly recognizing tribes' right to eminent domain, it has actually limited tribes' ability to eminent domain in other situations. Specifically, in Public Law 98-513, a law pertaining to the Lake Traverse Reservation, Congress stated that that particular tribe can exercise tribal eminent domain but just on trust land. Congress limited that particular reservation's ability to exercise eminent domain, and petitioner is unfamiliar with any congressional statute which limits or abrogates the Minnetonka Nation's right to exercise eminent domain with the entire boundaries of the reservation.
Is this land trust land?
It is not trust land, Your Honor. It
Is
is
it owned
fee land.
by a Minnetonka citizen?
It is not owned by a Minnetonka citizen.
In that case, how does the Minnetonka Nation have jurisdiction over a non-citizen's non-trust land?
First, Your Honor, to the point of the land status in question. In McGirt versus Oklahoma, Justice Gorsuch said that once a block of land is set aside for an Indian reservation, no matter what happens to the title of the individual parcels within the boundaries of the reservation, the entire block of reservation status is intact until Congress explicitly states otherwise, meaning that the entire boundaries of the reservation, since it is not diminished or disestablished, we believe that the land status in question doesn't necessarily matter, even if it is unrestricted fee land. But to your second point, in regards to the citizenship of Mr. Randall, it is the position of the petitioner that Mr. Randall's Indian status is sufficient to render him subject to the nation's power of eminent domain.
Would the state have had the power to condemn that land?
Yes, Your Honor, the state does have the power to condemn that land under the General Allotment Act, but that does not necessarily preclude the tribe's ability to exercise concurrent jurisdiction over the land through tribal eminent domain. Very recently, last term, in terms of criminal jurisdiction, this court found in Castro Huerta that both states and the federal government can exercise concurrent jurisdiction together. And until and unless this court or Congress explicitly states that the state eminent domain necessarily precludes the tribe's ability to exercise eminent domain, this court should not find that the tribe lacks the power of eminent domain simply.
But Counselor, those cases, McGirt and Huerta, Castro Huerta, those are criminal cases. How do they apply to eminent domain, which is not a criminal action?
Your Honor, in Plains Commerce, this court stated that there are two considerations in regarding civil regulatory jurisdiction over a potential parcel of land. The first of which is the land status. But secondly, the court went on to say, and I quote, "Moreover, when the tribe or tribal members convey the parcel of land to non-Indians, the tribe loses any former right of absolute and exclusive use of that land," meaning that the Indian status in question is valuable. And the Indian status test from this court is United States versus Rogers, a two-pronged test. First, the individual must have an ancestral connection to the tribe. I don't believe either side today will dispute that Mr. Randall is 3/16 Minnetonkan blood degree. That is satisfactory. The second prong is a little bit more complicated, but the tribe asserts that Mr. Randall still has sufficient Indian status. The Ninth Circuit in United States versus...
Counselor, how do you reconcile this idea that you're trying to convince us that Mr. Randall is Indian when federal laws such as the Indian Child Welfare Act, for example, would not extend to Mr. Randall's own children since he has chosen himself not to enroll?
Your Honor, if Mr. Randall was to have a child that had the membership requirements of the Minnetonka Nation and they decided to enroll, they could be a member within the tribe. They could meet the Rogers, that second Rogers prong. But membership status isn't dispositive in this case. In the Ninth Circuit's decision, United States versus Zepeda, they looked at the Rogers test and found that the second prong can either be met by membership or sufficient connections with the tribe. Mr. Randall, this case is extremely similar to the Ninth Circuit or Seventh Circuit's decision in Ex Parte Pero. In Ex Parte Pero, the individual was eligible for membership.
Counsel, if Mr. Randall were not an Indian, may the tribe still be able to condemn the personhood easement under Montana?
Your Honor, it is under Montana, it evaluates member versus non-member. And my co-counsel, Mr. Berzer, will discuss that a little bit more. For purposes of this first issue, though, it is the position under Plains Commerce that Indian status is critical in determining whether the tribe can exercise that power of eminent domain. In Ex Parte Pero, that specific court found that eligibility for membership, living on a reservation, and having some connections with the tribe is sufficient to render them subject to the nation's power of eminent domain. Here,
Counselor, do we have to, do we make an independent determination, or are we bound to accept Minneshanka's determination of Indian status of this Mr. Randall?
Your Honor, this is a question of law. It is reviewed de novo, but in regards to the factual findings of the Minneshanka Nation Supreme Court, petitioner asked this court to grant deference to those factual findings, since the Minneshanka Nation found that Mr. Randall lived on the reservation, had been on the reservation, and his family had been there for over 100 years, and that he has taken advantage on pages 8 through 9 of the record of the Minneshanka Nation services.
Question. I'm sorry. Before we get to that, I think all of certainly the Supreme Court cases you've mentioned that apply the Rogers test are criminal jurisdiction cases. We've never, to my knowledge, applied Rogers on a civil regulatory case. Can help maybe persuade us that leap is one that should be taken here?
Yes, Your Honor. The fact that the Rogers test should be the appropriate test for purposes of civil regulatory authority goes directly back to equal protection concerns. Many membership standards require there to be some degree of blood level for that individual to enroll. If this court was to adopt the Rogers standard for purposes of civil regulatory authority, it would be essentially going away from any equal protection concerns for a multitude of reasons. First of which is that the Rogers standard is not alone a racial test. It is both a racial test and a political test. And this court in Morton versus Mancari stated that so long as standards aren't solely relied upon a racial test, racial standard, then that particular finding is political.
But isn't the political part of Morton versus Mancari the citizenship in the tribe? I mean, it seems to me this goes in the opposite direction.
Your Honor, several courts below have not only looked at the political, but also the social and practical connections of the individual. Mr. Randall here has lived on the reservation, taken advantage of the nation's services, and has formed those connections with other tribal members throughout his daily life.
Counsel, we're dealing with a restricted allotment where the restrictions had been removed.
Thank you.
Thank you. Petitioner number 2, oral. You may proceed.
Chief Justice, Justices, and may it please the court. My name is Chris Berzer, and I represent the petitioner, the Minneshanka Nation. This is a case about an Indian nation's right to protect the Minneshanka cane, a sacred plant intimately linked to the well-being and existence of the Minneshankan people. For 2 reasons, this court should reverse the 13th Circuit and hold that per Montana, the Minneshanka Nation possesses the inherent authority to protect Minneshanka cane on Mr. Randall's lands. First, destruction of the Minneshanka cane poses a direct threat to the health and welfare of the Minneshanka Nation. And second, Mr. Randall has entered into consensual relationships with the Minneshanka Nation. In Montana,
Counsel, is there any evidence that the planned development here will actually affect Minneshanka cane in Mr. Randall's instance?
Your Honor, the record is not explicit on this point. However, it certainly seems, based off of the scale of the development and the vigor with which Mr. Randall has challenged this action, that it would affect the Minneshankan cane. However, perhaps more importantly, the framework that this court has set up to evaluate the health and welfare Montana exception suggests that this court should evaluate tribal power in the abstract and not only with reference to particular non-member conduct. That is, this court should evaluate the practical implications of affirming the 13th Circuit here, which would be to greenlight other non-members to challenge their easements.
Sir, I was curious, what impact does the Minneshanka Nation's determination that the cane has personhood make? What difference does that make?
Your Honor, the personhood status of the Minneshankan cane should weigh into this court's evaluation of the health and welfare impact that destroying the Minneshanka cane has on the Minneshanka Nation.
What does it mean by personhood? What difference does that make to us?
Your Honor, the record reflects that there are extensive cultural, ecological, and environmental ties between the Minneshankan people and the Minneshankan Cane. Given the failure of common law conceptions of property to account for cultural interests, the Minneshankan Nation has taken a rather unique approach by granting personhood status to the Minneshankan Cane. Now, this decision is grounded both in precedent and in science. In terms of precedent, the law has long recognized the legal fiction of granting personhood status to non-people. Think of business entities like corporations and LLCs. Scientifically, humans' understandings of plants have come a long way. More recent understandings suggest that plants are significantly more sophisticated than original understandings of them. That is, networks that exist within the roots of plants mirror the way that brains
Counsel,
neural pathways.
Montana is a very high bar. Don't the cases all suggest a very high level of impact involving violence or other kind of deadly perils is necessary in order to trigger Montana's exception?
Your Honor, a couple of responses. No doubt respondent will point to some of the lofty language that this court has used to describe the health and welfare exception. It's important to note that this court has shied away from using some of that language of requiring catastrophe or threatening the subsistence of an Indian nation in its most recent application in Cooley. Furthermore, to the extent that that standard remains good law, petitioner would urge this court to revisit that standard. Requiring that there be catastrophic consequences creates a situation where the rule swallows the exception and the exception becomes elusive.
How would you frame that then, counsel?
Your Honor, the better framing is perhaps directly from Montana, that the non-member conduct must pose some direct threat to the health and welfare of the Indian nation. Now, even if this court does not overturn that lofty standard, petitioner still believes that it is satisfied here. The record reflects that Minneshankan cane fulfills vital cultural, ecological, and environmental function for the Minneshankan Nation.
How do you square that with something like Ling versus Northwest Cemetery, where we allowed a forestry service road that to be put in that all but destroyed the religion of that particular tribe?
Your Honor, petitioner believes that this court can and should revisit that case. However, the extent of the relationship between the Minneshankan people and the Minneshankan cane is greater here than existed there, both because it serves vital cultural interests. The record reflects that the Minneshankan people rely on it for food.
Counsel, in Montana, the court did not believe that tribal hunting and fishing regulations were vital to tribal interest. How is cane different?
Your Honor, again, the record says that the connection between the Minneshankan people and the cane is far deeper than the connection between the Crow tribe in Montana and the fish there. Not only does the Minneshankan Nation rely on the cane as a food source, but it's also used as a material to construct a variety of basketry, weaponry, tools, and small structures. Environmentally, it's relied on for land and water management. The record says that a number of studies have been conducted that show that the Minneshankan cane filters air, water, and soil, that it sequesters carbon and produces oxygen at rates far higher than other plants, and that ecologically it serves as a critical habitat for a number of other species.
So I'm sorry, quick question. So far, these are all Montana too, right? The second Montana exception arguments. Do you have a Montana one argument also?
Yes, Your Honor, petitioner does. Petitioner believes that in this case, Mr. Randall has entered into a consensual relationship with the Minneshankan Nation, both procedurally and substantively. Substantively, Mr. Randall has lived on the reservation for effectively his entire life. He cooperates with neighboring ranchers, and he accepts services from the Minneshankan Nation in the form of flood aid. That is, he receives sandbags. The Minneshankan Nation provides sandbags to Mr. Randall, which helps him to prevent flooding of his farmlands.
But don't they provide those to everybody?
Your Honor, the record is not clear about the extent of aid that the Minneshankan Nation has provided. However, this is a deeper form of cooperation than may appear at first glance for two reasons. One is that a single flood is capable of destroying or wiping out a year's worth of a farm. And the second is that during these times of emergency flooding, it's fair to assume that the Minnesota Nation has limited resources and that it has chosen to invest its limited resources in helping Mr. Randall abate the worst effects of flooding. Now, this court has insisted that there be a nexus between whatever relationship exists between the non-member and the tribe and the proposed regulations.
What effect, if any, should be given the fact that he has been eligible for citizenship and he is elected against seeking same?
Your Honor, no weight should be given to that because the Montana exceptions already assume that he is a non-member. That is, that he has chosen not to join the Minnesota Nation. Should this court side with petitioner on issue 1, then it's not even necessary to get to the Montana exceptions because the nation would have civil jurisdiction over Mr. Randall to begin with. Here,
are you conceding that he is not a Indian?
No, Your Honor. The Montana arguments are in the alternative.
And what does your tribal court mean by saying that he is an Indian but not a citizen? What's the difference? How can that be?
Your Honor, the citizenship seems to refer to the specific question of whether he is enrolled as a member, which the record is clear that he is not.
Can you be an Indian without being a member of a tribe? I don't understand how that works.
Yes, Your Honor, and I would point back to my co-counsel's arguments about determining Indian status through the Rogers test, and although that membership status may be a factor that weighs on whether or not he is an Indian for legal purposes, it is not dispositive of that.
Is it relevant, even if not dispositive? And if so, what level of relevance does it hold?
Your Honor, it is certainly relevant as a part of the second factor under the Rogers test of the extent of political and social connections between Mr. Randall and the Minnesota Nation. However, it is not dispositive, especially given the length and extent of dealings between Mr. Randall and the Minnesota Nation. As I was mentioning, this court...
What is the citizenship of this Minnesota Cane, if any?
Your Honor, it's clear from this court's precedent that Indian nations have the right to determine tribal membership. That is, that's wholly within the purview of the sovereignty of Indian nations. Here, the Minnesota Nation has chosen to exercise that power in the somewhat unique way of granting personhood status to the Minnesota Cane.
Did they say there was Minnesota Cane a citizen, or did it just say that it's a personhood?
Your Honor, the latter. It is not explicit that it has granted membership to Minnesota Cane. However, petitioner believes that that's a fair assumption based off of the record and the phrasing of the enactment of the personhood ordinance. Given that, petitioner believes that that should weigh heavily in this court's calculation of the health and welfare prong of the Montana exceptions, because destruction of a portion of the Minnesota Cane is effectively destruction of a portion of the Minnesota people. As I was mentioning,
can cane actually be valued? I mean, wouldn't it be necessary for us to know the true significance of it to then evaluate whether or not it falls within the second Montana exception?
Your Honor, I believe that the record contains sufficient information to infer the extent of importance of the Minnesota Cane. Additionally, several lower courts, and particularly the Ninth Circuit and FMC Corporation, has said that threats to cultural resources, threats to natural resources, and particularly ones with particular cultural significance, come within the purview of the health and welfare exception under Montana. And petitioner would urge this court to make that explicit. That is, threats to cultural interests constitute threats to tribal health and welfare. As I was mentioning, for the consensual relationship exception, this court has insisted that there be a nexus between the non-member's relationship and the regulation. Here, that nexus exists in the form of land and water management. Mr. Randall has accepted flood aid to help abate the worst effects of flooding. And in turn, the Minnetonka Nation seeks to use the Minnetonka cane on his lands to help control water quality and land quality. This also furnishes an independent basis by which this court may conclude that the Minnetonka Nation has jurisdiction to protect the Minnetonka cane, and that is the Minnetonka Nation's treatment as a state status. The Minnetonka
Counselor,
Nation.
why do you not just impose some sort of sanction against Mr. Randall personally, since you believe that he has the status of a tribal member? How does that authority extend to the land? We've agreed it's not a trust, it's not trust property.
Yes, Your Honor. The petitioner does not believe that simply sanctioning Mr. Randall is sufficient to adequately protect the Minnetonka cane over the long run. That is, even a simple sanction against Mr. Randall for violating the easement would not ensure that his successors also respect the cane and respect those
If you
easements.
can't sanction him, can you zone this land? This fee simple patented land?
Your Honor, yes. Under these articulations of either of the Montana exceptions, petitioner does believe that it has the right to zone this land. And that also seems to be supported by this court's holding in Brindale, which presented relatively similar facts here. So yes, it does have the ability to zone, and given that ability, it also has the right and ability to condemn easements over the land. Lastly, Mr. Randall also consented to jurisdiction procedurally. He appeared before the legislative condemnation hearing. He made arguments on the merits, and he lost. Based off of that, he should not be able to subsequently challenge. Thank you.
Thank you. We'll now hear from the respondents. Oralist number 1, please. You may proceed when you're ready.
Mr. Chief Justice, and may it please the court. I'm Joshua Bertolotto, and along with my co-counsel, Claire Song, we will represent the respondent, Mr. Aaron Randall, today. I will focus my arguments on the issue of Indian classification. The question before this court today is whether respondent meets the classification of Indian as to be subject to the civil jurisdiction of a federally recognized tribe.
Do you concede, counsel, that he need not be a member?
In the context of civil jurisdiction, Your Honor, whether or not he is Indian is irrelevant, but the membership status is what the regulation of domestic relations amongst members from U.S. v. Willer. It is required for membership to be there. Indian status is not as much a consideration. It's about whether or not he's enrolled.
How does he have standing to bring this?
Well, Your Honor, in National Farmers, it does require that civil adjudicatory jurisdiction of a tribe first be exhausted through tribal court remedies, and that's exactly what respondent did here. We then challenge that through the proper processes of federal court as required through National Farmers, Your Honor. Further, respondent asked this court to find that Indian is solely a political classification reserved for citizens of federally recognized tribes, and that respondent, as a non-enrolled,
Okay, will you say that again, please?
Your Honor?
Restate that.
Yes, Your Honor. Respondent asked this court to find that Indian is a solely political classification reserved for citizens of federally recognized tribes, and that respondent, as a
Aren't
non-citizen.
the cases, though, all over the place as to what criteria must be used in order to determine that? That doesn't tell us anything because of the federal requirements, both in Indian Health Service and criminal prosecutions. There's all these little caveats as to criteria, sir.
Well, Your Honor, since this case is ultimately about civil jurisdiction of the tribe, we can look to cases such as Morton v. Moncari and U.S. v. Willer that all caveat the regulation of tribal civil jurisdiction in any case to be amongst members. It's about that membership aspect of someone, regardless of their Indian status. It's about that affirmative enrollment within a tribal government. that political status is ultimately what's at issue here. In
Counsel,
USV
why should we accept the argument that just because someone's not enrolled, they're not Indian? Does that mean then that babies born into tribes that that they do not have automatic enrollment, that they themselves are then not considered Indian?
Well, Your Honor, again, they may still be considered Indian in that case, but ultimately, if it was a question of if the tribe could have civil jurisdiction, in something like the Indian Child Welfare Act, that is explicitly detailed in that specific case, but here something for civil jurisdiction over eminent domain within the reservation is not as explicitly defined. So ultimately, it is up to this court to define what that would mean in this context. Additionally, in US v. Antelope, this court actually held that the federal regulation of Indian tribes is the governance of once sovereign political communities. And in Antelope, the court was actually analyzing the Indian status of a criminal defendant for purposes of federal jurisdiction under the Major Crimes Act. The court in Antelope ultimately held that Indian status is not and cannot be based in whole nor in part upon impermissible racial classifications. Thus, again, to Your Honor's question, it cannot be based on something solely like Indian status. It has to be based on the political status of citizenship within a tribe.
So is it your position that Antelope overruled the Rogers case?
Your Honor, no, Your Honor. I think ultimately what the court said in Antelope, what this court was saying in Antelope is that these impermissible racial classifications cannot be the sole deciding factor in something like political status. It cannot be the reason why the court ultimately decides that someone is or is not politically Indian for the purposes of federal jurisdiction. And just
Didn't in Joseph and Sandoval, though, didn't we as a court look at the habits of the Indians themselves to determine whether the laws would apply to them?
Your Honor, yes, that is correct. And
then that's not just purely a political status.
Your Honor, that's correct. It was more of a somewhat kinship analysis, I guess, to understand relationships
Which is what
within the community.
the Minnesota Nation is doing at this time.
But we as respondent assert that respondent has no such affiliations or associations with the tribe that would render him.
Counsel, didn't Mr. Randall receive an education reserved exclusively for Indians at an Indian boarding school?
Your Honor, the record does not necessarily reflect whether that was a federal Indian boarding school as we know it today, or whether that was reserved solely for someone who had Indian status or membership within a tribe. So while the record is a little unclear on that specific issue, it would seem somewhat problematic given the history surrounding Indian boarding schools to assume that that was in some way a federal benefit that the respondent received in any way. Quite the opposite, Your Honor. So petitioner today asserts that because of both respondent's ancestry and residency, that the respondent is subject to the tribe's jurisdiction. However, both of these characteristics are not chosen by the respondent, but are imposed by circumstances beyond his control. He was granted this allotment, it was passed down, his ancestry was passed down as well.
If he was granted the allotment or if he inherited it, no one required him to retain it. And is it so that the claim is merely based on ancestry plus residency, or do we have more information than that suggests that there was a choice to remain on that property in that place during that time?
Well, Your Honor, the record reflects no specific choice that the respondent made to be on that land, but I think ultimately what the court can understand from the record is that the respondent received this land, inherited, as you said, which means he owned it outright when he was eligible to obtain the right to that land.
Counsel, isn't Mr. Randall quite active in the nation? I mean, doesn't he attend the church of the nation as well? And isn't he known under the tribal court's findings to be quite an active participant within the nation?
Well, Your Honor, while I do agree that respondent attends church on the reservation, I do think it doesn't stand that he is still affiliated with the tribe beyond simply attending church to near where he resides. That's something I think that is common amongst most people. But in this specific case, it would also be a somewhat problematic course for this court to take to use something like religious affiliation to then apply a political status upon someone, relating religion and political status. Typically not done in this court. I'd like to also address a little bit of petitioner's argument in regards to the Major Crimes Act and how that applies here, because we do assert that respondent meets neither of the or meets the first element of the Rogers test, but does not meet the second element of the Rogers test, which, as we've discussed, is the relations to the community, kind of recognition within the community as Indian. We did mention, obviously, that he does attend some church services on the reservation, but beyond that, he's received some assistance, but that assistance was, as petitioner mentioned, in the form of sandbags, and I think we could all agree that that assistance is more in the form of a friendly neighbor, also with the tribe protecting its own land interests in the area, preventing flooding from going onto their land. So certainly not a federally reserved benefit for someone who has the political classification of Indian. Your Honor's respondent is not an Indian, as Indian status is ultimately a political classification tied to citizenship in the tribe. And where, as respondent is here, is a non-citizen, the tribe cannot assert its jurisdiction over him.
So it's completely up to him then, again, back to the question about the effect, if any, that his failure to enroll as a citizen of the Minnesota Nation, that's determinative of the question.
Yes, Your Honor. We do believe it is dispositive, and this court has ruled in several occasions that any regulations, especially civil regulations amongst like the domestic relations, has to be confined to amongst the members of the tribe. That's again from U.S. v. Wheeler. That was again affirmed in Morton v. Moncari, where Indian status cannot be the sole issue at play. It has to go back to the political classification of citizenship.
So assuming that we accept your characterization of our case law and citizenship in the civil regulatory context, so the sort of Morton and Mancari point you were just making, petitioners have argued that we should expand the Rogers understanding of Indian status to the civil side. Why should we not do that? And their argument is it would be more efficient in some ways.
Well, Your Honor, I do agree that it could potentially be more efficient. Ultimately, they're very different things we are talking about here. In something like criminal jurisdiction, we do see ultimately things like Public Law 280 that involves state governments taking over federal jurisdiction. This is something we see within the criminal jurisdiction side within Indian country that is ultimately kept separate from what we see as civil jurisdiction.
But
within
that
Indian
we
country.
just decided last term, I believe it was in Cooley, that we could have a drug stop on reservation by a tribal officer on the Crow Reservation, and that over non-members, not over, and that would be okay because of the health and welfare of the keeping that type of stuff off the res.
Yes, Your Honor, that is correct.
And so it seems that we have jurisdiction there, or that Minnesota would have jurisdiction there.
Well, Your Honor, while my co-counsel will more deeply address that concern of specifically whether that satisfies that health and safety requirement under Montana, we do assert that something like drug trafficking or the toxic spills that were in other cases that have been seen before district courts, this is obviously a much different issue here. This is not at all imperiling the subsistence of the tribe.
But if the cane is a person and he destroys the cane, it sounds to me that he's committed murder. Would he not be subject to criminal jurisdiction at that point?
Well, Your Honor, that ultimately is a separate question, but that we do believe that could be possible. But ultimately, respondent here is Your Honor, can I ask you to repeat the question one more time? I just would like to provide a direct answer.
All right, well, I was just concerned about if he would destroy the cane and the cane is a person, would he not be subject to some sort of criminal jurisdiction at that point for punishment purposes?
Your Honor, that is possible, but I would direct the court to the fact that the record does not. Thank you.
You may proceed, ma'am.
Mr. Chief Justice, and may it please the court. My name is Claire Song, and I represent Mr. Aaron Randall, the respondent. Now, you just heard from my co-counsel about the impact of Indian status and membership on the tribe's civil jurisdiction over respondent. My task is to cover the impact of his land status on the civil jurisdiction of the Minnesota Nation. The 13th Circuit held...
Could you answer the question
Yes, sir.
asked by our co-justice?
Yes, Your Honor.
When time ran out, please.
Would that be if the respondent would be subject to criminal sanctions?
Yes.
Your Honor, I have two responses to that. First, criminal and civil jurisdiction are separate. Criminal jurisdiction has its own body of case law. Civil jurisdiction is subject to United States versus Montana. And second, Your Honor, that has not happened. The respondent has not made any efforts to destroy the Minnesota cane. Now, of course, if that were to happen, then the Minnesota Nation might bring a separate suit. But as it were, Your Honor, that is not the case today. We ask this court today to affirm the 13th Circuit's holding that tribal eminent domain power has been implicitly divested over non-member fee lands for three reasons. First, this court has never recognized eminent domain as an inherent sovereign power reserved by tribal nations after the passage of implicit divestiture. Second, insofar as Congress has either recognized or delegated eminent domain power to tribal nations in the Indian Civil Rights Act, that still is limited to the tribe's power of self-government. Your Honors, petitioners brought up Section 1302A5 of the Indian Civil Rights Act, which I believe is important to read in whole. It reads that no Indian tribe may, in exercising powers of self-government, take any private property for a public use without just compensation. Now, Your Honors, self-government is a critical determination today. United States versus Montana is dispositive of the scope of tribal civil jurisdiction, tribal self-government in the realm of civil regulatory jurisdiction. Finally, Your Honors, the third reason that we ask you to affirm the 13th Circuit's holding is that Minnesota Nation's eminent domain action against respondents' non-member fee land is implicitly divested in United States versus Montana because neither exception is satisfied. Your Honors, condemnation...
Madam Counsel?
Yes, Your Honor.
I'm assuming that the primary interactions are cognizant arm of the federal government interacting with the tribes is the executive branch. Is that correct?
I'm sorry, I did not hear the first part.
I assume that the executive branch is the primarily responsible for interactions and relations with the tribes.
The executive branch, yes, Your Honor.
All right. And so when they articulate a policy, is that is one which this court would generally recognize. Is that correct?
Yes, Your Honor. However, that still must be subject to the recognition and whatever title has been extinguished by Congress. Now, Your Honor.
All right. So then,
Yes,
but the United States is a signatory to the Declaration of Rights of Indigenous Peoples from the United Nations, and even the EPA has adopted that as a policy and procedures in its 2014 statements of policies. Under Article 11 therein, it states that all states, member states, which would be the United States, have to take actions to rectify those prior wrongs regarding the cultural and spiritual values. It seems to me that when that is declared as a personhood from the Minnesota Nation, that this federal government needs to recognize that and undo the harm which we, unbeknownst to ourselves, did.
Yes, Your Honor. I'll address the United Nations and the EPA separately. First, the United Nations Article is not necessarily binding. If it were to be binding, it would be binding on Congress. So if Congress tomorrow passed a law declaring that it was the policy of the United States to protect Minnetonka cane and other similar plants which may have been harmed or devastated by colonization, then that would absolutely be binding, Your Honor. However, it has not. So the Indian Civil Rights Act in United States versus Montana is the best law on point. Next, in the EPA has indeed recognized the Minnetonka Nation as a state under the Clean Water Act's administration. However, the Clean Water Act does not itself serve to magnify or further clarify the civil, adjudicatory, or regulatory jurisdiction of a tribe. So while the tribe may be the best suited to determine its best management practices, which in this case it has by declaring its policy to protect Minnetonka cane wherever possible on the reservation, it also has the authority to administer that best management practice. However, the authority to administer and determine the best management practice does not in and of itself magnify the scope of the tribe's civil jurisdiction. It must still satisfy one of the two exceptions to United States versus Montana, and Your Honors, it does not. First, the respondent has not consented to the tribe's jurisdiction in this case.
Well, how can you say that? He's gone through exhausted all of his remedies in tribal court.
Yes, Your Honor. However, that is for the purpose of complying with this court's holding in National Farmers, rather than consenting to the regulatory jurisdiction of the tribe. Mr. Randall might consent to the judicatory jurisdiction of the tribe without agreeing with the regulatory jurisdiction, Your Honor.
Do you perceive eminent domain as a regulatory determination or an adjudicatory one?
The respondent holds that eminent domain is a regulatory jurisdiction because condemnation proceedings are a civil action. Mr. Randall has not consented to the jurisdiction of the tribe, and his ongoing neighborly relationships with the tribe and his social relationships with other members of the tribe and folks in the community of the tribe does not constitute a consensual relationship listed in the first Montana exception. The first Montana exception clarifies the meaning of consensual relationships as including business dealings, commercial dealings, contracts, leases, and other arrangements. Mr. Randall has entered into no such arrangement with the tribe. Furthermore, tribes only implicit consent to tribal jurisdiction through reservation dwelling is inconsistent with the tribe's status as a diminished sovereign. That is the entire purpose of United States versus Montana, Your Honor, to establish the importance of fee versus tribal versus trust land status in determining the scope of tribal civil regulatory jurisdiction.
So let's say, let me understand this about the contracts that they can have an interaction based upon a commercial dealing. Is that correct?
Yes, Your Honor.
And so if they were interacting with a Minnetonka corporation, they may have jurisdiction because of that would be a Minnetonka entity. Is that correct?
If respondent entered into a direct contract or a business dealing with the Minnetonka corporation, then yes, Your Honor, but that is not the case.
But this is a Minnetonka person in the nature of the cane. So how is that different than a Minnetonka corporation? They're both juridical persons.
Your Honor, I have two responses to that. First, the primary protection accorded to persons, the personhood of Minnetonka cane, is that of condemnation, which is a civil action and subject to the limitations in the United States versus Montana. And second, yes, Your Honor.
Would you then, this is different, you're saying, but would that then be an alternative or possible for them to have zoned, which they did not do?
Yes, Your Honor. If zoning were at hand, then I believe the question presented would be different, but as it were, the Minnetonka Nation did not pass any zoning laws to protect the Minnetonka cane. Now, we acknowledge that Minnetonka cane is important spiritually and culturally to the tribe. However, the condemnation is still a civil action, and as such, the implications of condemning respondents' land in particular is far too broad to qualify for the second exception. Your Honors, the record reflects that after the condemnation easements were passed, the Department of Ecological Resources of Minnetonka Nation surveyed 100 parcels of land, surveyed all lands, in fact, within the reservation, found 100 parcels on which Minnetonka cane existed or thrived, and of those 100 parcels, 99 either consented or accepted the just compensation offered by the Minnetonka Nation in order to allow the Minnetonka Nation to condemn their property. So, Your Honors, in effect, 99% of all found cane within the reservation has already been protected.
And
Your
so,
Honors, yes.
pardon me, the determinations of other property owners in either accepting the just compensation or determining that there was not even a need for condemnation to trigger the just compensation somehow excuses Mr. Randall from the effects of what would happen here?
Your Honor, our assertion is that the effects of what would happen if Mr. Randall does not comply with the condemnation action are not severe enough to meet Montana 2. So the context of the 99 other parcels is relevant to determining the degree of harm that would be caused to the Minnetonka Nation if Mr. Randall did not comply with the condemnation. Now, if Mr. Randall's property were the only property where Minnetonka cane was still found, that would be a different balance, Your Honor, but as it were, that's not the case. Mr. Randall's property is only one of 100 parcels of land where Minnetonka cane is found.
But if you take $1 from 1 million people, you still end up with $1 million taken. And so couldn't the overall effect, particularly given the science that has been suggested vis-a-vis the effect within the root communication of the plant, how can we just slice things so mathematically to determine, or to use that as a basis upon which to determine that the outcome and the effect wouldn't be deleterious at the very least and possibly even catastrophic?
Your Honor, I am not a scientist, but the scientific record indicates to us that the efforts and purpose of the Minnetonka cane condemnation easement is to protect and encourage the growth of new Minnetonka cane. So, Your Honors, we presume that the Minnetonka Nation has some further plans, both to protect the existing Minnetonka cane on the reservation, as well as to perhaps take samples from those cane, grow them in the lab, make new strains, make new varietals of the cane. That would be very effective.
But based upon
yes.
what you have just said about the 99% or 1% of the harms, aren't we bound by the Minnetonka court as to their determination as to the nature of harm? That's a factual determination.
Your Honor, the Minnetonka court's determination is to cane generally. However, we assert that their decision is not adequately descriptive of the actual harm that would be caused to Minnetonka cane and thereby the Minnetonka people if Mr. Randall did not comply with his condemnation. Their statements are relatively global to all cane and the general connection between cane and people, which, Your Honors, we do not deny today. However, the record is insufficient to suggest that the refusal to comply with the condemnation would somehow lead to catastrophic or imperilous results to the Minnetonka people.
But isn't this an attack on the culture of the Minnetonka people? Isn't Mr. Randall a non-Indian refusing to recognize the personhood of this cane? Isn't that a direct attack by him on the culture and the religious practices of the Minnetonka people?
No, Your Honor, we assert that it's not for two reasons. First, because even though Mr. Randall has not availed himself as a citizen of the Minnetonka Nation, these people are still his neighbors and he's lived on the reservation for long enough, established relationships. There is no malice in Respondent's claims. However, we do assert that Respondent should be able to use, alienate, develop his private property as he sees fit.
Well, we know that can't be the case. Excuse me. We know that can't be the case because even people who have fees simple absolute can be limited by zoning, by restrictive covenants, by restrictions pertaining to 5 tribes land, and so forth.
Yes, Your Honor, and if zoning had been on the table here, we would be discussing the impacts of whether or not Minnetonka could pass a zoning protection for Minnetonka cane. However,
Counsel, the
yes, Your
easement only prohibits Mr. Randall from using the land subject to the easement in the manner which harms the cane. He could still sell the land freely, even though future owners would likely be subject to the same restraints. Doesn't this mean then that the case does not fall within the Plains Commerce Bank ambit?
Your Honor, two responses to that. First, the respondent has been in years-long negotiations with outside developers for his property. So he has built some reliance as well as sunk some cost into establishing the development of his land, not only for his personal benefit, but also for the economic benefit of the tribe. And second, Your Honor, we assert that the fee status of the land is sufficient to qualify this under the restrictions of United States versus Montana. And in Plains Commerce, this court also held that conduct which imperils the subsistence of a tribe is that which is regulable. So, Your Honors, that might include the storage of millions of pounds of toxic waste near a body of drinking water. It might include tortious or criminal mismanagement of fees, funding that supports the tribe's livelihood. But, Your Honors, those holdings regard discrete individual conduct rather than the simple desire of respondent to develop his land as he sees fit. In closing, Your Honors, for the foregoing reasons, we ask this court to affirm the 13th Circuit's holding that eminent domain power of the Minneshanka Nation has been implicitly divested in this case over non-members on non-member fee lands. This court has never recognized eminent domain as an inherent sovereign power of tribal nations. Congress has explicitly limited the power of eminent domain by tribal nations to the scope of their own self-government.
What do you mean they've explicitly? I thought that what doesn't the Indian Civil Rights Act?
The Indian Civil Rights Act states that no
They
Indian
have to
tribe...
compensate for takings, right?
Yes, but also in relevant part, Your Honor, that no tribe may, in exercising powers of self-government. That phrase is absent from the Fifth Amendment of the United States Constitution, which affords eminent domain with only two limits: just compensation and public use.
How can
Your
this
Honor, we
not be
assert-
the exercise of self-governance if we're dealing with cultural, ecological, and environmental effects for the Minneshanka Nation that are intense? How can that not be self-governance?
Your Honor, if the effects were so deleterious as to imperil the tribe's subsistence, if, for example, this was the last or one of the last Minneshanka cane specimens on the reservation.
Is that for us to determine, or is that for the Minneshanka to determine?
That is for the Minneshanka to determine, but however, the Minneshanka did not make that determination. They simply asserted that tribal sovereignty and Minneshanka cane were inextricably linked, which
That seems a determination to me.
However, thank you, Your Honor.
Petitioner, you have 3 minutes?
2 minutes, Your
2
Honor.
minutes. You may proceed.
May it please the court, 2 points on rebuttal. First, respondent asserts that criminal jurisdiction should not factor into this court's decision. This argument plainly evades the plain text of the tribal code. Pursuant to the Tribal Code, Section 201 and 401, respectively, on pages 22 and 23 of the record, it states that this personhood easement will be enforced through criminal penalties in tribal law enforcement officers. But even if that is not enough to apply the Rogers standard, this court should still do so in terms of efficiency in the guidelines that several circuit courts have said that it is the only widely accepted, generally adopted test for Indian status. Secondly, the Minneshanka Nation has the power from Santa Clara Pueblo versus Martinez to determine its own membership standards. The tribe has exercised this power to grant a personhood status to the Minneshankan cane. And that means that the destruction of the Minneshankan cane is destruction of the Minneshankan people. And respondent has not grappled with this argument. And viewed in these terms, the Minneshanka Nation is authorized under Montana to take regulatory action to protect its cane and its people, the Minneshankan cane. For these foregoing reasons, petitioner respectfully asks this court to reverse the decision of the 13th Circuit Court of Appeals. Thank you.
Thank you very much, counsel. This matter stands submitted. And I will note before we retire. retire to chambers to judge the merits of the matter presented.